Good afternoon. At least it's afternoon here in eastern Idaho. Let's see, it's around 2:45 in the afternoon on Thursday. And I wanted to give you a little update on the Chad and Lori Daybell case. Seems like as the trial gets closer and closer, there's more and more updates. Some of these are pretty technical or procedural type things. Others are interesting to read. Regardless, this is the court process in motion, and we should be expecting a lot more filings. So just filed today, Lori Vallow Daybell is asking Judge Boyce to dismiss her case due to lack of a speedy trial. When you are arrested, when you are indicted, you have the right to a speedy trial under the Constitution and under Idaho law. And most defendants, at least in my experience, waive that right to a speedy trial. They figure that the longer time they have to prepare a defense, the better. And that gives the state a longer time to prepare their defense or their prosecution. But Lori Vallow has not waived her right to a speedy trial. She's been given the chance multiple times to go before the judge and say, I'm going to waive my right. Chad has. So Chad has been able to, prepare his defense. But Lori has consistently said, I'm not waiving my right. I want a trial. I want a trial. I want it to happen. Well, she has been in jail as of today, 1,100, let me get it right. I think 1,169 days, according to her attorneys. 1,169 days. Ironically, I was just looking at my records. I confronted Lori and Chad 3 years ago today. It was January 26th in Hawaii. So her attorneys are saying, listen, she's been in jail for 3 years, almost. She has not had a trial. Judge dismissed the case. The state has not had good cause to get her before a jury. You need to dismiss the case. Now, there has been a lot of stuff that have happened over the past 3 years. She's been declared incompetent twice. So 10 months, her case was on hold. You remember that was last year. Then she was declared incompetent earlier the first incompetency was from 2021 to 2022. And then there was another competency issue last fall for about a month. So take away that time, her defense attorneys still say, no, that you need to dismiss the case because her rights, her constitutional rights to a speedy trial have been violated. Let me read to you kind of the timeline. So she was arrested February 20th of 2020 in Hawaii, $5 million bond. She was charged in Madison and Fremont County. Then in May of 2021, she was indicted by the grand jury, and the previous 2 cases were dismissed. Then in April of 2022, she was arraigned on the indictment. So you have 6 months from the arraignment. So that would have been October of 2022. That's when the state requested that the trial be pushed off. There were second settings, so the trial was set to begin in January. It didn't happen. Now it's set to begin in April. So this is from the court documents just filed today. The first trial setting in this case was for October 2022, since that was within 6 months of April 2022. The government then asked for more time, and the court granted the request, and the trial was set for January 9th of 2023. This violated her right to a speedy trial. Lori Vallow Daybell's defense team questioned her competency in October through November. A 40-day delay caused by the competence review still doesn't justify a trial setting 3 years after her arrest and almost 1 year after arraignment. The government still has an obligation to bring her to a speedy trial which complies with the Constitution and Idaho Code. From her arrest on February 20th, 2020, until the current trial date on April 3rd, 2023, is 1,169 days without a trial in any of the cases, her 3 cases. From her arraignment on April 19th, 2022 until the current trial date is 349 days, obviously more than the statutory 6-month time limit. Her constitutional rights, including her right to be presumed innocent and her right to a speedy trial, have been ignored by the government. It is undisputed that Lori Vallow Daybell has demanded her speedy trial and has never waived her constitutional rights. She is prejudiced every day since she's in jail and unable to post bond. The court has repeatedly reminded the government that it will respect her constitutional right to a speedy trial. Her attorneys go on to write, The government cannot show good cause to bring Lori Vallow Daybell to trial over 3 years from her arrest and almost 1 year from her arraignment. This court should find that the government has not met its burden to uphold her constitutional rights. This case should be dismissed. Now, this is an interesting filing. I would be highly doubtful if Judge Boyce does dismiss it, but it is the rights to a defendant to have that speedy trial, and they're arguing that it has not happened in this case. So that will be heard. Her attorneys will argue this before Judge Boyce. If you've been following this case, you know that it's interesting because her case is tied to Chad's. They're being tried together. Chad has waived his right to a speedy trial. So Chad, his trial could be held in 5 years, and you might recall that his attorney has asked for continual continuances. His attorney wants more time. Lori Vallow's attorneys can't ask for those continuances, really, unless she waives her right to a speedy trial. So you've got the one side saying, push it off, push it off, push it off. You've got the other side saying it needs to happen now. And then you've got the judge who has to weigh the rights of both sides. And Judge Boyce has repeatedly said in court that he's concerned about Lori's length in the Madison County Jail because she has not waived that right to a speedy trial. So he's got to keep her constitutional rights in mind as along with Chad's. So that's an interesting court filing that hit today. Also, her attorneys have subpoenaed an attorney with the LDS Church for all of Lori's church records, accomplishments, achievements, temple marriage records, anything basically about her membership in the church. And they have subpoenaed JJ's school. I believe she's the president of the school in Arizona for all of his school records. So those are a few things that came down. Next hearing will be, not October. Next hearing will be February 9th in Fremont County, where these issues will be discussed. The issue about having the case completely dismissed, and then a couple of other issues. And then trial, we're still set for the trial, April 3rd in Ada County. So somebody asked me, sent me an email the other day asking when jury notifications will go out. If you live in Ada County, when will you get a notification that you might be on the jury? Well, right now, the attorneys are coming up with questions that will be on that jury form. So they will agree to questions that should be asked of each juror. And they could call, you need 12 jurors. They could call maybe 200 people in and hope that out of the 200, 12 are picked. I read this morning or heard this morning that in the Murdaugh case that's happening right now, I believe in South Carolina, they called 900 people in. And out of the 900, they picked the 12 plus the alternates. So I don't know how many people will be called in from Ada County to be questioned, to be on this jury. But let me know would you want to be on the jury? I mean, would you want to sit through 10 weeks of this trial if you lived in Ada County and you were called? And do you believe that you could be fair and unbiased, and that you would have an open mind about this, and that you could do it? That's my question. A lot of people don't want to be on a jury. Personally, I'd love to be on a jury, any jury. I have been summoned for jury duty, but I wasn't picked. In fact, it didn't even happen. But I have a journalist friend of mine who was actually called for jury duty. He didn't think that he would be picked. He was, because they said, you can be fair based on your job. You can be fair. You can hear both sides. You can, listen to that. So he was picked for the jury, and he actually served for about a week. And I remember, this was years ago, we did a story because we were covering the case, but we couldn't say he was on the jury. We don't reveal who's on the jury till after the fact. So as far as, back to the original question, the summons for the jury, I don't know when those would go out. I would imagine probably in March. And they're not going to send you a letter saying, you've been picked to be a juror for the Daybell trial. It's just going to be you've been picked for jury duty, show up at the courthouse, and then when you show up that day, that's when you may find out you're on it. Interesting side note, my wife was once picked for jury duty, and she was actually picked to be on the jury. And they were ready to go to trial, and the defendant walked in, sat down with his attorney, saw the jury, and then they said, we're going to settle. So it went all the way up to that point, and they settled. We've covered trials before where just a few months ago, there was a trial we covered where there was one day of the trial, and then that night they reached an agreement and the trial didn't happen anymore. So that could potentially happen in this case. In the Daybell case, they could go and maybe have one day of trial and then they decide to settle. I doubt that would happen, but it could. And they could still settle between now and the start of the case in April. So we're about to post a whole story on East Idaho News about this new development, about Lori's attorney asking the judge to drop the case. I'll link to the court docs. You can read those if you want. And we'll continue to keep you posted on this trial as it continues. Thanks so much for watching. Yeah, let me know. Do you want to be on the jury? Would you want to be on the jury? Do you think you could be fair and unbiased? Do you think you could give a fair shake, go in there open-minded and give them their rights? Let me know. Obviously, the evidence in this case might be pretty gory, pretty graphic, but let me know. Have a good day.